Swayam Prabha. Digital India. Educated India.
Dear students, now is the time to take up a new study on public interest litigation in India. You all know about this topic, public interest litigation, but how it is important in the field of jurisprudence, that we will try to understand. Students, in this lecture we will see what is public interest litigation. What is the significance of public interest litigation? Who can file this PIL? In short, public interest litigation can be also called as PIL. What will be the procedure to file PIL? What are the stages of evolution of PIL in our country? And then we will also see landmark cases on PIL. Finally, we will see that what are the emerging issues which are dealt by the PILs, and then lastly, what are the challenges and debates relating to the public international law, public interest litigation. What is public interest litigation? Public interest litigation is a legal action filed in the court for the protection of public interest. Public interest litigation is filed to protect the public interest, not the individual interest, because for protecting the individual interest, individuals will have to go to the court themselves. But when there is a public interest, now this is the new jurisprudence. A start of new jurisprudence was made that when there is a common interest which may be called public interest, then that action can be initiated in the court of law. So, who can initiate this kind of litigation? This is initiated by any person or even a group who must act on behalf of the affected persons or the members of the public. Public interest litigation does not require the person filing to have been personally affected. Now, this is the new jurisprudence. Normally, I told you that the person whose rights are violated, that person can go to the court and take a favorable remedy. But if suppose if that person cannot go to the court, that can also be the situation. The person's rights are violated, but the person is not in the power to go to the court. Power means that there is, because of reason of poverty, a person may be very poor, cannot afford the cost to go to the court, because in the court fees will have to be given, and then a charge which will be taken by the advocates, that will also be huge, that may be huge. So, how can a person who is having such kind of situation of poverty, how can that person go to the court? Now, these are the things which have prompted a new jurisprudence in our country, and therefore, public interest litigation, we will try to understand about it. This kind of litigation is also termed as epistolary jurisdiction. What is the meaning of epistolary jurisdiction? That means that even a person can write a letter to the Supreme Court, and Supreme Court will initiate the proceedings on the basis of that letter. So, that was the time, this public interest litigation started in very late 70s and early 80s in fact, and therefore, in those times letters were common, and in those times the letters were sent. If a letter could be sent by an aggrieved person because he or she could not afford the cost to go to the court, in such cases what will be possible, that the person can even send a letter to the court, and that will be having the power, the Supreme Court will have the power to exercise jurisdiction in such cases. Such kind of jurisdiction is called epistolary jurisdiction. Now, we will try to understand what was the need in those times to start this new jurisprudence. Public interest litigation, what was the need of it? You know that the adversarial system is being followed in our country. Adversarial system is a product of common law family of legal systems, and in adversarial systems what happens, that there will be the rule of standing before the court. Who can stand before the court? This is called locus standi in law. The technical word is locus standi. So, who has the locus standi to stand before the court? Normally, in the adversarial system, the person whose rights are violated, the person who is aggrieved, that person will have to go to the court, and the person enjoys that kind of power, that is called locus standi. The locus standi is given to those persons whose rights are violated, who is aggrieved, but this is the British era and British era rule, and this blinkered rule of standing that was not favoring the common masses of our country. Majority of the population in the late 70s and 80s, they were living in poverty. There were not the situations that they could afford the cost of the court. The people of the country, they lacked access to the court. But in those times, the court came to the occasion, rose to the occasion, and tried to shift the center of gravity from the traditional individualistic position of standing to the community oriented standing, and that will be called public interest litigation. So, community orientation, that was needed. Who will stand on behalf of the common people, and who will tell the court that if the person who is affected and his rights are violated, if that person is not able to come to the court, then someone else can also come on behalf of that person. Now, in such case, can the court say that no, you have no locus standi? This is a very challenging thing, and this challenge was overcome by the Supreme Court in the late 70s and early 80s. Because the court thought that the system of British era adversarial system, and if we follow it rigidly, then what will happen? The system will crumble under the burden of its own insensitivity. The court must be sensitive. The court must understand the society, the needs of the society. The court must understand that accessibility to the court is very important. The court must understand that the constitution, where it has been laid down in the preamble itself, that we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens a just society, an equitable society. We have to give justice, social justice, economic justice, political justice, equality of status. How can it be done? It cannot be done if it will remain only in the preamble. It cannot be done when it will remain only in some provisions of our constitution. it has to be acted upon. And therefore, in the late 70s, when the judiciary, the highest judiciary of our country, when it came to see that there was or there were some lawyers who wanted to stand on behalf of those persons who suffered from poverty, and therefore they could not even defend themselves in the courts, and therefore they could not come to the court, and they could not hire a lawyer, they could not afford to pay the court fees, they could not afford to pay the stamp fees. Then in such case, what will happen? Whether the court should not stand to the occasion, the court should not rise to the occasion, and therefore this new jurisprudence was started. It started in the way that access to justice will be widened. The net of accessing justice, that should not be a small net, but that net should be a wider net, and only then you can empower the marginalized. Only then there will be the redressal of the gaps in the legislation. Legislature was doing something, but it could not also make the laws which were needed. Therefore, who will do it? Judiciary rose to the occasion and tried to intervene in such situations. So, judicial activism was needed. It is not to interfere, it was not to interfere in the work of the executive, it was not to interfere in the work of the legislature, but it was a very just kind of interference by which the courts could allow more access to justice to those people who are marginalized, who suffered from poverty. And also later on, what happened, that when the problems relating to environment arose, the problems relating to social issues arose, like disabled rights arose, then also courts rose to the occasion and widened this rule of locus standi and public interest litigation. Those petitions, those were accepted and allowed. It is a low cost legal action, and therefore, when someone will go for filing public interest litigation, then do not think that it will involve huge costs. So, cost wise also it is not that costly as compared to the adversarial system, and therefore, public interest litigation is a significant improvement in the jurisprudential understanding of in our country. You will say that who can file a PIL? I said that the whole rule of locus standi has been changed in case of public interest litigation. So, having that fact in mind, any citizen or a group of citizens can file a PIL on behalf of those persons whose rights are violated. There is no requirement of having a personal stake in the issue, and therefore, this rule of locus standi was liberalized. There was a need to liberalize the whole technical thing, and that was done. Therefore, now non-governmental organizations, social activists, public spirited individuals, they can also file public interest litigations. We will now move on to look at the procedure of filing a PIL. How you can think of filing a PIL when you become an advocate, because you must be an advocate. Without that, or you must be a social activist. So, that is also one way. So, there is no need to always be an advocate for that. So, you can also, a common person can also go to the court. Grounds for filing public interest litigation. There should be a strong case based upon public interest. If there is self-interest, if there is personal interest, that will not be public interest, and therefore, that kind of petition will be rejected by the court. So, what will be the ground? Ground will be public interest. Why you are going to the court? To save the public interest. You have to prepare what? You have to prepare some evidence to support your claim that this is a public interest. You will have to seek legal aid from public interest lawyer, because sometimes they will tell you that how your case will be stronger. Now, before filing the PIL, you must know about the jurisdiction of the courts. PIL cannot be filed in the district court. PILs can be filed only in the Supreme Court of India and in the high courts. So, what is the provision? Under Article 32 of the Constitution of India, a person can file a public interest litigation in the Supreme Court, and under Article 226 of the Constitution, a person can file a PIL in the high courts. So, under these two provisions, a PIL can be filed either in the Supreme Court or in the High Court, because both these courts enjoy the power of what we call public interest litigation. And what is the method of filing? There can be direct filing. You can submit your petition directly to the court with some fees, or you can send your claim or your petition on by way of registered letter. You send a registered letter containing the petition with supporting documents to the Chief Justice of that High Court or the Chief Justice of the whole country. Or you can also avail free legal aid services to file this public interest litigation. So, free legal aid service also is one of the way in which PIL can be filed. And once you file it, the court process will start, and what will happen, that the registry will scrutinize the petition, and thereafter once it is satisfied, when the registry of the High Court or the Supreme Court is satisfied that there exists prima facie public interest, then there will be notice to respondents which will be served. And thereafter, once the notification is there, when the notice is served, then the hearings will start, and final stage will be the judgment. Some of the additional points that you also can note, that court fees in PIL cases are lower than the regular suits. So, when you file PIL, you should not worry that it will be that much costly, but the process can be lengthy. You know that pendency of the cases in the courts, and therefore, with that in mind, you should not say that PILs will be quickly disposed of. So, it is unlike the writ petitions which are quickly disposed of, but PILs may not be quickly disposed of. It depends upon the load of cases before the court. Once we have understood these basic elements of public interest litigation, then we will try to understand the stages of evolution of PIL in our country. I told you that the whole, we can call it a movement. So, we can say that initially it started in the very late 70s. So, we can say pre-1980s, and thereafter the next stage was, and that was the intensive stage of public interest litigation jurisprudence in our country, that was early 1980s. And thereafter the last phase can be the present phase. So, the whole evolution of public interest litigation in our country, that can be divided into three phases. We will look at these three phases and let us give some more time to understand that how important were those phases. The first phase was pre-1980s, when I told you there was limited access to justice, there was poverty, and most of the people of our country, they were living in poverty. They were marginalized from the mainstream. The mainstream lived in the cities and towns, and the people who lived in the villages, and that too in the villages, there were many people who did not have even the means to have 2 times meal in their villages. So, how could they think, and their rights were violated daily or on a regular basis. So, how can this be done? So, the locus standi rule, that was changed in the late 70s. I told you that what happened in the late 70s, and late 70s, there is one example of Hussain Ara Khatun case. This case will open up the eyes that how the court stood to the occasion. You know what happened in Hussain Ara Khatun? The under trial prisoners, there were so many under trial prisoners who were there facing the trial, but they were inside the prison. And how could they do not afford the cost of defending themselves? Because of their poverty. They went to face the trial and they were unrepresented. And therefore, what happened? That the person could again go to the prison. Now, Hussain Ara Khatun was one of such under trial prisoners. She was facing the trial, she was undergoing the whole trial process, and she was imprisoned. But she was the only bread earner and she was also imprisoned. She had kids also, but still she was imprisoned, and she was imprisoned not for a day, but suppose if she was the trial was going on for the punishment of an act of theft, then the punishment might be having just 3 years, but she was undergoing the trial, she was in the prison more than 3 years, and therefore the thing was that when a person has even exceeded the limit of punishment and she was in jail, what can be done? The trial is not ending. So, she has already served the punishment. What can be done? Hussain Ara Khatun's case was very difficult. No one would hear it. But then what happened? A news item that was published. Indian Express is a newspaper where the story of under trial prisoners, those were published. And Hussain Ara Khatun was imprisoned in a jail in Bihar. And what happened? That when this news item was published in Indian Express, a lady advocate who was practicing in the Supreme Court of India, her name was Kapila Hingorani. And you know what? Kapila Hingorani, she was not insensitive. She was so much sensitive that when she read this story, she said that, my God, what is happening? Should I not do something? Should I not file some petition on behalf of them? Because this news item has shaken my heart, and therefore I am going to file this petition in the Supreme Court. But then she was also reminded that how can you go on their behalf? Will the court accept your petition? She said, okay, I am going to the court and I will try to convince the court that let me take up this case and let the court liberalize the whole strict rule of locus standi. Kapila Hingorani filed this petition and she said that this is because of public interest that I am filing this litigation. And you will be surprised to know that at that moment of time, when this Hussain Ara Khatun case was being heard, the judges of the Supreme Court, they must be given applaud for this, that they said that this petition we will allow. And thereafter what happened, that when the Supreme Court allowed this petition, when Kapila's case was heard by the Supreme Court, even when Hussain Ara Khatun was not present, because she was facing the trial in Bihar, and then what happened, that the court says that this is what is happening. Because of poverty, someone is not coming to the court. She is not only facing the trial, the rich persons, they are facing the trial living in their homes, but she is a poor lady. She was the only bread earner and she had also kids. Still she was in jail. What is that happening? So the court issued directions that those under trial prisoners who have already served the punishment, the maximum punishment for which the trial is taking place, those persons must be released. And you know what? That after this PIL was finally disposed of, after that in the whole country, around 40,000 under trial prisoners, they were released. You see that how this success? The success was instrumental in improving the condition of those people, under trial prisoners, and Hussain Ara Khatun led by such example. This was the judgment in 1979. Perhaps this is the first reported public interest litigation case in our country, and therefore what I said, that late 70s, the public interest litigation, the new jurisprudence that was started in our country. Then came the Municipal Corporation Ratlam versus Vardichand. This was the judgment which was given by the Supreme Court in 1980, and the judges, again I say that judges of those times, those were like gods, and they were not insensitive, they were so much sensitive that when this, in this case, in Municipal Council Ratlam's case, what happened, that the city of Ratlam was having lot of problems relating to the waste disposal, and the roads were not cleaned by the municipal corporation, and thereafter the roads were filled with garbage, and the cattle, they were all roaming around on the roads, and therefore the people of Ratlam city, they said that what is going on, and there was a lot of a stench, there the smell, there was an alcohol plant, and they also sent the effluents from the alcohol plant into the nalas, and therefore what happened, that the people of Ratlam, some of the people of one of the wards of Ratlam, they came to the court. Not they went directly to the court, they went to the SDM and subdivisional magistrate, and they filed a petition that why don't you give the order under CRPC. And what happened, that under section 133 of CRPC, they prayed that subdivisional magistrate, he should issue an order or direction to the Municipal Corporation Ratlam that the roads be cleaned, and there should be more efforts to maintain the sanitation of the city. There will be no mosquito breeding, there will be no stench coming from the roads. So, what I tell you, that Municipal Corporation Ratlam was the case, and Municipal Corporation did not accept the order, rather it went to the court, and when the High Court again accepted that no, whatever was the action of the SDM, that was right, then not only that, Municipal Corporation went to the Supreme Court, and in Supreme Court, judges Krishna Iyer were there, Justice Chinnappa Reddy were there, and they said that the magistrate's order, we also say that that order was right. So, this was one of the first cases on public interest litigation. There was a public interest that the citizens of Ratlam, the persons who were residents of Ratlam city or Ratlam town, which is a very small town, and this was the opportunity given to the Supreme Court. Supreme Court says that this is the situation which is prevailing in almost all the municipalities, almost all the municipal corporations in our country, and therefore the court has to do something, and the court says that this is the duty of the municipal corporations not to neglect whatever duties are prescribed in the relevant legislation. There is Municipal Corporation Act, and in which municipal councils and municipal corporations, they have to perform their duties. So, this was another case which was very important in this, when we discuss public interest litigation, this becomes very important. There are certain more cases like ABSK Sangh, this was an association of employees of railways versus Union of India, and you know what, it was an unregistered association, but still they went to the court, that they were saying that they have a common grievance, and therefore they filed a writ petition under Article 32, which was converted into public interest litigation. Now, Justice Krishna Iyer, he was a great judge, and he held access to justice through class action, public interest litigation, and representative proceedings is the present constitutional jurisprudence. Now, this new jurisprudence, he used the word jurisprudence, he said that there is a need to have new constitutional jurisprudence, because our people, our fellow brothers and sisters, they are not doing good because of poverty and they cannot come to the court. We have to liberalize the whole rule, technical rule, the rigid rule, the British era rule. So, in this case also the court heard this public interest litigation. There are some more cases, because in those times there was a start and this could not be, this whole silsila that went on. And you know what, there have been some cases like Upendra Bakshi versus Union of India. Upendra Bakshi was a professor of Delhi University and he filed a writ petition in the court, and what he was saying that in Agra in Uttar Pradesh there were protective homes, and in the name of protective homes, the women who were there inside, they should be protected, but they were not protected. Rather, their modesty that was taken away, and there were some women who were trafficked women, and human trafficking was taking place, and thereafter child rights were violated. So, Professor Upendra Bakshi, he filed a public interest litigation along with another professor, and this public interest litigation was accepted by the Supreme Court. This is also a landmark judgment. This gave a new direction to the journey of public interest litigation. And then comes Bandhuwa Mukti Morcha case. Bandhuwa Mukti Morcha case, again in that case the question was raised that the laborers who are bonded laborers in our country, those bonded laborers mean that the laborers who were not given wages, but they might have been given some loan and thereafter they had to do some work and without any wages, without any payment. So, that was the time when the start in the filing of public interest litigation that started. Then there was a Swami, he filed a petition on behalf of these people, Bandhuwa Mukti Morcha, and he said that they are all Bandhuwa Mazdoors, Bandhuwa Mukti Morcha. So, it was a Mukti Morcha to liberate them. He wanted to liberate these bonded laborers. So, Bandhuwa Mazdoori should be prohibited, it should not be allowed. And what happened, that he wanted, because those child laborers, those laborers who became bonded laborers in the quarries, in the factories, in the stone quarries in Haryana, now those were to be saved. Their childhood rights were to be protected, and therefore the rights which were going to be infringed or which were infringing, those have to be undone, and therefore public interest litigation was filed in the court, and again the court accepted this public interest litigation. And you know what, court passed many directions, and even moving beyond, the court also made a commission and they formed a committee that yes, these people, they will go investigate, because in public interest litigation there is not the other party which will always say that because the party who has come to the court, that party is not a very rich party maybe, or because he is taking the cause of other people, and therefore the court sometimes takes upon itself that to form commissions, to form some commission of inquiry. And in Bandhuwa Mukti Morcha case also, the court wanted that we will investigate, and then the court passed certain directions. Then comes MC Mehta series of cases. In the late 80s, MC Mehta, you might have heard about this activist. This MC Mehta filed so many public interest litigations, but his area was environment. He wanted to file public interest litigations to protect the environment. You remember the Taj Mahal case, and you remember the Ganga pollution case. Now, those cases were filed. He said that even when we have said that our Ganga is Mata for us, but still the pollution level in Ganga, that is increasing. Who will do something for Ganga? He said that the Ganga should be made clean, and he filed a public interest litigation. Likewise, he had the Taj Mahal was surrounded by industries, and the smokes which were emitted, those smokes finally also passed through the Taj Mahal, top of the Taj Mahal, and it eroded the shine of Taj Mahal. So, you might have heard about Taj trapezium case, that was also by way of public interest litigation. Did MC Mehta say that no, I will not go to the court because my right is not violated? His right was not violated, but still he went to the court on behalf of a public interest. What was the public interest? To protect the environment, to save the environment, and that was also accepted by the court. There was another example of SP Gupta versus Union of India, in which some of the lawyers, they went to the court and they said that the transfer of a high court judge and the appointment of some of the additional judges, that needs to be examined by the court, because they were saying that executive is going to influence the decisions, and these advocates, they went to the court, and this case is known as judges transfer case. And you know what? This was also by way of public interest litigation. The judges who were transferred, they did not go themselves, but the lawyers, they went to the court, and this was a great time, because in this case also the judgment which was passed, that was very important, because that changed the whole course of the appointment of judges in our country. Before that case, you know, the senior most judges, those were appointed, but sometimes executive did not appoint the senior most judge as the Chief Justice of India, and SP Gupta case, that became the landmark judgment. After this case only, this whole collegium system has come, and now the judiciary is claimed to be the independent judiciary, because the people, the highest, the judges in the highest court, some of the judges of the highest court, they enjoy the power to appoint the judges because of this judgment, and that is SP Gupta versus Union of India. So, what we have seen, that early 1980s was an intense phase in the development of public interest litigation. Now, we will see that some of the other cases like Olga Tellis versus Bombay Municipal Corporation. Again, this is an example of municipal corporation which was doing nothing. People in Bombay, when you visit Mumbai, you will find that many poor people, they are just sleeping on the pavements. There was no shelter, and when this case was filed in 80s, most of the people of Mumbai, they were just sleeping on the pavements, and some car, some vehicle will come, and sometimes their life will be lost. So, where they will go? They were working in the day, but in the night when they wanted to just sleep or take rest, where will they go? Because they could not afford the rent in Mumbai. So, and what happened, that municipal corporations, they came and they said, no, you can't sleep here. So, this was the situation. Where will they go? Whether the poor, they will go themselves to the court, it will be difficult. So, again, some public spirited citizens, they filed this case. This is known as Olga Tellis versus Bombay Municipal Corporation, where the court gave direction that there is a right to shelter. If the municipal corporation does not provide some common shelter homes, then where will these people go? Whether they do not have the right to life. And the court interpreted Article 21, right to life, in a new way, saying that right to life includes right to get shelter. Who will give shelter? They were working for the improvement of Mumbai, for the economic improvement of the whole city, but then in the night they can't take rest. Therefore, it was the duty of the municipal corporations to build some shelter homes where these people, they would reside, they would take shelter during the nights. There was also a case of Vishakha, that was the late 1990s. Now, if you look at Vishakha case, this was the case which changed the direction in the whole journey of PIL, because that was a landmark judgment. How? Because there was no law on sexual harassment. before this judgment came. And what happened, that a lady who was serving as a very small Anganwadi worker in Rajasthan, and she was a bold lady, she did not like child marriages, and she witnessed child marriage in her village and in the adjoining village. She went herself to the spot and she wanted to stop the child marriage. And in that village, there were very strong people. They had caste associations, and therefore they said that how can a lady say that no, child marriage has to be stopped, and they wanted to take revenge. And you will wonder, what was the method of revenge? The method of revenge was raping the woman and killing her. So what happened, that Bhavri Devi was raped by those people of the village, and she was also killed. So in such case, what will happen? Who will save those class of people? They were small people, they were defenseless people, and if the court will not rise to the occasion and the court will not liberalize the rule of standing, then what will happen? Now in such case, because this PIL movement had gathered momentum, there was one NGO who filed a writ petition which was named as Public Interest Litigation, and that NGO was Vishakha. Vishakha filed this writ petition, this public interest litigation in the court against the state of Rajasthan. And you know what? That in this case, when court was hearing this whole problem, then the question arose that whether our country has not made any law to prevent such sexual harassment cases, because she was working as a very small worker of the government, and the state should have protected her life, her dignity, but the state could not do it. The state did not have, when this matter went to the court, the state was saying there is no law, and therefore when she was sexually harassed, but then there was no law to prevent it. So the court says that we have the convention on the elimination of discrimination against women. Our country was a party to this convention. 1979, when this convention on the elimination of discrimination against women, that convention was signed by the then government of the country. Then did we sign thinking that we will not make a law in our country? Way back in 1979, we had signed this convention and we decided that we will not make any laws. So the court was annoyed, and justices of the Supreme Court, like you might have heard about the name of J.S. Verma. Justice J.S. Verma was there in the Supreme Court, and what he said, that no, this is the time that we will frame guidelines to prevent the sexual harassment in the public places. And he laid down guidelines, and those guidelines, although those were technically given the name of guidelines, but those guidelines were to be followed as law for the time being. And the court also directed the government that why don't you make laws on it? And this judgment came in 1997. And you will wonder, people will say that this was judicial activism. But then, was it a judicial activism? When the legislature does not make laws which were essential, which were needed, then the court does something. Is this an example of judicial activism? The answer is no. Because even when Vishakha judgment was passed, even when Vishakha versus State of Rajasthan was passed, after that it took many long years until Nirbhaya case happened. There was no law passed by the parliament on sexual harassment. So the judges, they do wonderful jobs, and sometimes these new jurisprudence which came up in this field, that is called public interest litigation, and Vishakha versus State of Rajasthan is one of those great examples. I have told you about the Hussain Ara Khatun case. I have told you about Vishakha versus the State of Rajasthan case. We have also discussed about MC Mehta case, and then we will also try to understand about some other issues which are being dealt by the public interest litigations. You might have heard about the right to education. Now, do you think that this right to education law, now it has been also given constitutional status, do you think that right to education law, that was only because of the legislative efforts? No, this was also because of public interest litigation. Even before this RTE, Right to Education Act, was passed in the Parliament, way back in 1993, public interest litigation was filed in the court, that was called Unni Krishnan case, and in Unni Krishnan case, the court very clearly held that the children up to the age of 14, they must be provided with free education, because children, they should not go to on the streets to seek alms, they should not go to the factories, they should not waste their childhood in doing some labor or menial jobs, but they should go for education, because education is very important. There has to be a right to education, and Unni Krishnan case, that was also an example of public interest litigation, and the court says that right to education up to the 14 years of age, that is very important, because after that the state role may come to an end, but till 14 years means that if when a person goes to the class 8 or 9, till then at least the state should give free education. We have discussed about the bonded labor problem and how it was saved, the situation was saved by the Supreme Court, and I have told you about the story of Swami Agnivesh who went to the court. We also can see the example of disability rights which were promoted by the Supreme Court by way of public interest litigation, and even when the Persons with Disability Act has been passed in 2016, 8 years back this act was passed, but even today some of the public interest litigations, they are filed in the court, in the Supreme Court. The recent example is Seema Girja Lal versus Union of India. In Seema Girja Lal, the non-formation of district level committees under section 72 of this act, that has not been done, and some people like Seema Girja Lal, she went to the court praying that, look, lordships, right to persons with disability, that act has been passed, but at the district level, which is very important, at the district level when the committees will not be formed, how will this be implemented, how this law will be implemented? So, when the legislature passed this statute and when it will remain unimplemented, what will be the fate of the disabled people? Most of the people who are poor and disabled, they cannot go to the large cities and in the capitals where the high courts are normally there. So, in such cases, what should happen? So, Seema Girja Lal case, in this case the Supreme Court says that district level committees must be formed immediately. We can also give some examples relating to consumer rights. In SP Mittal versus State of Uttar Pradesh in 1989, there was a problem that an eye camp was organized and many people went there to have their eyes operated, cataract operations or for some other ailments, and you know what, that the eyes were operated, but due to the medical negligence, many people, they became blind. And then the question arose that because this was a free eye camp, whether there will be any remedy. Then some people, they went to the court, filed a public interest litigation and said that what is this happening? 40 people were blinded and they wanted that their eye would be operated because there was an incentive that this will be an eye camp and their eyes will be operated by the people who are skilled, who are having knowledge, adequate knowledge, but still they were blinded by the negligence of the medical people. So, the court gave direction that those people must be compensated. By way of public interest litigation, the court have even gone beyond just not to say that okay, this is the direction, but the courts also give compensation when the public interest litigations are heard and the judgment is given. If the court finds that there needs to be compensation also, compensation can also be granted by the court. So, some of these issues I have told you about the issue of environment. Almitra Patel's example we can have. Almitra Patel, she studied in foreign countries, but when she came back and she was residing in the city of Bangalore, what happened that she was shocked to see that the solid waste in the city of Bangalore, that was not properly disposed of. So, she was annoyed to see that there is no rule. The constitution we have, it says that there is a right to life, but how can this right to life will be exercised when the garbage in the city is not taken away by the municipal corporations in time, and therefore, how this problem will be solved? There were no rules on solid waste disposal. Every home generates the solid waste, but what would be the rules relating to that? This was not clear. Almitra Patel filed a public interest litigation in the court, and you know what? She was successful. Her standing was accepted. She lived in Bangalore city, but she was not saying that only my right is violated. She took the cause of others and she said environment is very important. Right to life cannot be enjoyed when there will be a neat and clean environment, and the garbage must be disposed in a proper way, because before that there were no solid waste disposal safe places, and those solid waste would be they were littered on the public roads. So, Almitra Patel's judgment, after that, now we have the solid waste rules which have been promulgated all over the country. So, you see that the whole jurisprudence in this field of public interest litigation, that must be understood, because without this we will not understand that what is currently going on. So, in the present day, what I will tell you that it is a very active tool. Public interest litigations remain an active tool for the citizens of our country to address social issues, and in that way they will be able to enforce the fundamental rights. The examples of child labor, how the child labor were saved by the court, the examples of environmental protection cases, those will tell you the lesson that public interest litigation, what kind of important tool is this. PILs also hold the government accountable for its actions and inactions. You have the example of Municipal Corporation Ratlam, you have the example of Almitra Patel, you have the example of Bombay Municipal Corporation versus Olga Tellis. All these examples show that if PIL would not have been there, then what would have been the fate of those people who were just wandering on the road, who could not even sleep after their work, and those persons who were children, but still they were serving as a bonded laborers. Some other cases like Armando Gonçalves versus State of Goa, which was decided by the Bombay High Court in 2021. You know what? In 2020, when the corona came, the COVID pandemic came, at that moment of time, it was very difficult for the citizens to appear in the court. Although court was also very innovative, court changed the rule that there is no need to come to the court in person, there can be the facility of video conferencing. But even after that, there was the problem of shortage of oxygen. Oxygen was not supplied in many cities, what to talk about the villages, and therefore many public spirited citizens, they went to the court. They wanted that there should be a public interest litigation filed in the courts, and what happened in Bombay High Court? There were a lot of petitions. In Delhi High Court also, lot of petitions were being heard on everyday basis. relating to one or the other issues of corona pandemic, like oxygen supply. This issue, every day one or the other bench, they decided, they gave directions in Delhi. And likewise in this Gonzalez case, Armando Gonzalez case versus State of Goa, what happened, that the Bombay High Court gave directions that supply of oxygen to a medical college. There is a famous medical college in Goa, Goa Medical College. Even there was a shortage of oxygen supply. And you know what, that when Gonzalez went to the court came to the rescue of this Goa Medical College, because doctors, they did not want to go to the court directly, although the patients were suffering, but still the public spirited citizen, she went to the court, and then the directions were given. So what we see, that the public interest litigations have become an important tool, but still there are challenges and debates. Some people go to the court filing some petitions which are frivolous in nature, which are not public interest litigations, but which are publicity interest litigations, which are not public interest litigations, but they are personal interest litigations. Now, when these kind of litigations will be there in the court, do you think that this will be entertained by the court? Because courts get flooded with so many petitions on such flimsy grounds, or because of personal publicity. Now, these clog the system of judiciary and delays genuine cases. Therefore, the court takes a very strict kind of notice of such kind of people who do not go to the court for public purpose, but they want their own private purpose or publicity purpose. Some people will go to the court to settle personal vendettas. There will be some political agendas. Some people will go to file public interest litigation to get information. Like there is a recent case of an advocate of Delhi who went to the court, and one of the thing he says that information was not given by the authorities. The court says that this is not the way that you will file PIL for that. You will have to go to the concerned authority. And you might have heard that even a law student filed a public interest litigation in Delhi High Court seeking that bail should be given to the CM of Delhi. Now, the court was wondering that how come this student who has no interest in this way, that how this thing can be heard, because bail bond will be not given by the student, but it should be given by the CM of Delhi or the lawyer appointed by the CM. So, in that case, the court took very strict notice of this position and imposed cost on that student. So, if a PIL is misused, the court can also impose cost on those persons, and sometimes even heavy cost is imposed. So, you see that these are the challenges. It should not be misused, it should not be abused. The process was having a solemn purpose. That solemn purpose must be taken care of. Only then the person must file the public interest litigation. Otherwise, it will not only waste the time of the court, but it will also be a situation where people will laugh at you. So, this should not be the situation. Therefore, these are some of the challenges and some of the debates which are going on, and you must whenever you have time, you should look at these judgments. You should read the judgments on PIL, and then you will understand that at least you must read the late 70s and early 80s judgments, so that you will understand that how the whole jurisprudence relating to a standing that was changed by the court, and in the last 80, 90 and in the last almost 50 years now, the situation is also very good, that public interest litigations are not only being filed, but it has been very much an active tool for giving new directions in public policies. Thank you for your attention. I hope that you must have enjoyed this lecture, and we will meet next time. Thank you so much. you.